Judge Andrew Napolitano is Fox News senior judicial analyst. So they're gone. She said that she deleted her personal emails at her presser, but now her lawyer has come out and said, and as for that server, which normally would have a record of deleted emails, he says it has been wiped clean. There is no remaining documentation and nothing on the server that would show us what happened to them. That's what he claims.
Well, technically, we don't know if it's been wiped clean, but let's take his argument at its face value that they wiped it clean. The question is, when did they do it? She was subject to a letter sent to her by Congressman Chaffetz, chairman of a House committee, in September 2012, while she was still the Secretary of State, demanding all records and documents reflecting Benghazi. She was then
that would have encompassed emails. There's no question.
Oh, absolutely. Well, he used the word records, and he used the word records in the same definition that the statute does, which includes electronic records.
Exactly. The law is very clear that records includes emails.
That's a letter which puts a lawyer, Mrs. Clinton, and her staff
on notice.
Mills, I forget her first name. Cheryl Mills was her chief.
Uma Abedin.
Correct, they're all lawyers. Puts them on notice that they have to preserve the documents. 11 months later, in August of 2013, she's out of office, John Kerry is now in, the State Department receives 2 subpoenas from Congressman Darrell Issa. Not letters, subpoenas, essentially asking for the same thing. 2015 begins and a new Congress starts. So she's going to say that she no longer had the obligation in 2015 to comply with letters or subpoenas served in 2012,
That's ridiculous.
13, or 14. It depends on when she wiped the server clean.
But wait, before you get to that, she didn't do anything wrong if, as her lawyer claims, I mean, other than what we've already discussed.
Right.
But she, in deleting those emails, if they really were all personal emails.
She was wrong to delete anything, Megan, because the statute regulating this, the Public Records Act of 1950, as amended in her husband's years in 1995, requires that the government decide what is personal and what's not personal.
But normally in practice, the way it works is that the employee does it, and then upon leaving the State Department, even if you're the secretary, you sit down with the records administrator and you say, these are the documents, right? These are the ones I want to take with me because I think they're personal. These are the ones that are yours, that I created as secretary. And then that records keeper is supposed to do an independent review and say, I agree or don't agree, but there's a joint review. But didn't happen as far as we know.
She disabled the record keeper from doing it because she was the record keeper. Look, she was on notice from September of 2012 to preserve those records. Sometime between September of 2012 and March 2015, she had the records destroyed. That is either a federal crime or it's a disbarable offense for a lawyer.
I think if she destroyed the people's documents, she's in a lot of trouble. That could be obstruction. But if she only destroyed, as she claims to the lawyer, it was my emails about Chelsea, right? It was my emails about the wedding and so on. It may not be an obstruction charge, but it still goes to concealment. It raises the argument of concealment. She was the Secretary of State. She knew that there was a congressional investigation demanding all documents with respect to Benghazi, and she didn't so much as hit print.
She basically told the congressional investigators what they could do with their letters and with their subpoenas. She could have taught Richard Nixon a lesson. She utterly, totally, and completely frustrated their lawful ability to get their hands on her records, which they have a right and a duty and an obligation to examine.
And can I tell you the real capper here? That, you know, you've been talking about whether there was anything inside those emails that was sensitive or classified, and her people say, no, it was fine for them to be on her private server, nothing to worry about. Well, now that Congress is saying, give them to us, turn them over to us, her lawyer writes back, well, they may have sensitive diplomatic efforts reflected in them. We can't turn them over without approval of the state because there may be a privilege, privacy, or other reason why you can't.
Goodness.
Are you kidding me?
Well, I don't know how
it's okay to have them on the home server because there's nothing there.
I really don't know how they could make both arguments. Look, she is on such thin ice with respect to obstruction of justice and destruction of government records. If the government has any concept of the rule of law, they prosecute her for this. This is 10 times what David Petraeus is accused of having done.